So we're done with the topic 6.4, which is custodial investigation. So we have here 6.5, instituting criminal actions. So letter A is inquest procedures. So number one under inquest procedures is the inquest proceeding shall commence upon the presentation of the arrested person unless his or her absence is justified and witnesses by the police officer before the inquest prosecutor. The concerned police officer shall submit the following documents. So the person should be presented, um, or the arrested person should be presented under the court of law, and the concerned police officer should submit the following requirements. So here are the following requirements. There are a case referral signed by the chief of police, which was stated in the Annex QQ. Also, the affidavit of arrest, which was stated in the Annex RR. And C, statements of the complaints, Annex S. D, affidavits of the witnesses, if any, Annex T. And other supporting evidence gathered by law enforcement authorities during the investigation of the criminal incident involving the arrested person. So for number 2, the investigator shall also ensure that the documents to be presented during the inquest proceeding shall comply with the guidelines and procedures provided in the existing investigation manuals and procedures, including but not limited to the following. Letter A, AM number 21-6-08-SC, which is the rules on the use of body-worn cameras in the execution of warrants and warrantless arrest. This is wearing the body-worn cameras during the warrant of arrest or during the conduct of the warrantless or warrant of arrest. Letter B, PNP Criminal Investigation Manual 2011. Letter Z, DOJ-NBI-PDEA-PNP Unified Manual in the Investigation and Prosecution of Anti-Illegal Drug Cases 2021. Letter D, Murder or Homicide Investigation Manual. Letter E, Revised Standard Operating Procedures, Trafficking in Persons in Investigation Manual 2017. Letter F, Manual in Handling Children at Risk and Children in Conflict with the Law or CICL. And for the last, letter G, Women and Children Protection Desk Investigators Manual. So these are the guidelines and procedures that should be known by the investigators, and they should follow the procedures present in these manuals during the inquest proceedings. So we're done with the inquest procedures. So letter B is the waiver of rights. So the inquest shall proceed unless the arrested person opts for a preliminary investigation by executing the required waiver of rights under Article 125 of the Revised Penal Code. That is stated in the Annex U. So the waiver of rights, so we have here, the inquest proceeding shall proceed if everything goes according to the procedures. But if the arrested person opts for a preliminary investigation, then they should execute the required waiver of rights under the Article 125 of the RPC. For letter C, preliminary investigation and direct filing. So number 1 is preliminary investigation. This is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. So a preliminary investigation is an inquiry or proceeding that shows or determine if there is a sufficient ground to detain or to there is sufficient ground to show that the person committed a crime, if there is a crime committed, and probably the person is probably guilty of the act and should be held for a trial. So it is required to be conducted by the provincial or city prosecutors and their assistants, national and regional state prosecutors, and other officers as may be authorized by law. So the preliminary investigation are done by prosecutors, whether provincial or city, national or regional state prosecutors, which was authorized by the law. And before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. So, the preliminary investigation should proceed if there is an offense that had the penalty with at least 4 years, 2 months, and 1 day without regard to the fine. So number 2, that is for the preliminary investigation. For number 2 is direct filing. So for all other offenses where preliminary investigation is not required, the concerned investigator may file the complaint directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the office of the prosecutor. So, in Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. So, for all other offenses where preliminary investigation is not required, then the investigator could file a complaint directly to the municipal trial court or municipal circuit trial courts. In the following instances, the concerned investigator shall file cases with the prosecutor's office through regular filing when, letter A, the suspect has not been arrested, but there is sufficient evidence to warrant the filing of the case. So, if the person is arrested and there is a sufficient belief that also sufficient, of course, sufficient evidence to show that the person did this crime, then the prosecutor could file a case. Letter B, when there was an arrest by virtue of a warrantless arrest pursuant to Rule 113, Section 5 of the Rules of Court, but the reglementary period to file the case has already lapsed. So, there was the warrantless arrest was done. So the person was arrested through the virtue of the warrantless arrest, but the reglementary period to file the case has already lapsed or has already passed. So the investigator in charge of the case should file another case in the prosecutor office. So that is for the direct filing. So we're done with the preliminary investigation and direct filing under the instituting criminal actions. So let's go to letter D, attendance to court duties. So the personnel shall ensure that they dutifully attend court hearings. The concerned subpoena court process officer from the PNP shall ensure the attendance of the aforesaid PNP personnel by utilizing the PNP-E or electronic subpoena system. So for letter, that is to attend the their court duties, because they could be referred as witness. They could be referred as witness to the crime, especially if they are the person which was present during the criminal act. So letter E is monitoring of cases by the investigators. So after the investigators file the case at the prosecutor's office, they shall continuously monitor the case up to final resolution. So if the investigator was the one holding the case, they should follow up the case until it was done or until the court had off, I had given the order that the case was closed. So they also are required to upload in the case information and database management system all their cases folders and the updates. So they should do monitoring, and then they updated the cases, or they should be updated of what's happening on their cases, of course, because they are the officer in charge or the investigator in charge of the case. Also, they should update their case with the case information and database management system, which is the CIDMS, in their computer databases. So that's it for the um, instituting criminal actions. So review for the instituting criminal actions, which is 6.5 under the investigation operation, is number 1, inquest procedures. Letter A, that is inquest procedures. Letter B, waiver of rights. Letter C, preliminary investigation and direct filing. And letter D, attendance of court duties. And letter E, monitoring of cases by the investigators. Okay.